Good evening, everyone. Welcome to another Wednesday webinar with the Property Law Alliance. I'm Marley and I'll be your host for this evening. Welcome, Silna and Bruno.
Hi, good evening, guys.
How are you guys doing?
Freezing!
Yes. Absolutely freezing, yeah.
I
it's
agree.
Ridiculous.
All right, but let's get to it. Is there anything new happening in the property industry? Any new news?
Is there ever not?
Yeah, I get that.
Yes, so a property industry, I think one of the things that's quite relevant to the rental market specifically right now is the credit regulator. So let's all quickly think back to remember when the national state of disaster was declared on the 15th of March, and we thought, it's going to be like a quick 3-month thing. We're probably going to shake it off quite quickly. We had to already extend the national state of disaster. I do suspect that those extensions are going to keep on going. But so good times, if we think back to pretty much the 16th of March, we went into national state of disaster first day, and then going into lockdown on the 26th of March. Something very important that happened was the National Credit Regulator, in terms of the National Credit Act, immediately put a pause on the DS, so the running of days, when it comes to giving notice in terms of the National Credit Act to, for instance, blacklist someone. So if we look at that, to blacklist a person, you will have to give him a 20 business day notice that he will have to pay the outstanding amount. And if he doesn't do that, and you give those notices for 3 consecutive billing cycles, you can blacklist the person. And so details of this, please don't ask me. I'm not a credit bureau. I just know these things because of my close relationship with TPN. But other than that, this is stuff I just copied and pasted Michelle Dickens now. So if I miscopied, I'm sorry. But there's three repeating billing cycles, and then you can blacklist. What happened then, going into lockdown on the 26th of March, the National Credit Regulator said, no, we're not going to count business days as we normally did. So they put a pause on that. So all the letters of demand that was sent out prior to the 26th of March went onto a pause button. So now, as of today, whoop, we're counting again. So you're just going to pretend like this time period didn't happen, which is difficult to imagine because we've all learned so many new skills. I can bake. I'm on day 2 of a sourdough starter. You know, we can't really just undo the things that we knew. But when it comes to blacklisting, you just keep on counting. Please keep in mind that none of the business days in terms of the Consumer Protection Act was paused. So we've had leases cancelled, we've commenced evictions, we've been carrying on with that side of life pretty much as normal. It was just the blacklisting side and your time periods in terms of the National Credit Act.
Perfect. Thank you so much, Silna. Bruno, do you want to say anything about that?
No, nothing new. Yeah, that was perfect.
Okay. Then during last week's webinar, you said that you'll discuss settlement negotiations during this time with specific regards to the property industry. Are you negotiating with tenants to vacate? Have you considered what if the tenant doesn't vacate at that time, the specific time periods to consider? I don't know, Bruno, do you want to get the conversation starting with the settlement?
Absolutely. Thanks, Marley. So what we noticed coming out of the lockdown is a lot of situations arose where agreements were entered into, especially regarding the deferral of payment, deferral of rent, use of deposits, etc., etc. And some of these agreements also related to when a person was supposed to stay, until when a person stays on the property and when they anticipate moving out. So there were a lot of breaches over the lockdown period, and many leases did come to an end, or they're about to come to an end. So some form of agreement was entered into regarding cancellation and the tenant vacating the property. So we've received a lot of queries in this regard because people feel very comforted in the fact that they've entered into an agreement anticipating that the other party is going to comply with the agreement. And as humans, we'd all love to rest assured that when we contract, we honor that contract. But the reality is that many situations arise where people renege on these type of agreements. And especially you need to bear in mind the desperation now that has arisen may have caused a situation where the people agree to move out at the end of the month, but they don't actually have the money to pay a deposit, or somehow they can't find a place because they've got negative listings or whatever the case is. So how do we deal with these agreements now to get people to move out the property? And one of the problems that I've experienced is if we don't do anything about it and we simply rely on the agreement, all that lands up happening is you have to institute, let's say, eviction proceedings if the person doesn't move out after the date where the person was supposed to move out. And that wastes a lot of time. Now, naturally, it would depend on the amount of time you've agreed to, because maybe 1 week, 2 weeks, even 3 weeks, I would say, you know what, it's only 3 weeks, let it go. But as soon as it starts becoming a month, 2 months, 3 months, it starts becoming very risky to just leave it, just sign the agreement and not do anything about the agreement. So the conversation today is just relating to how we actually get these agreements to such a position where they're enforceable, and we can actually do something about them when somebody reneges on it.
Okay, perfect.
Yeah, I think, Bruno, I think what I've seen was actually, I've seen quite a few people then being super surprised once they have their settlement agreements in writing and the tenant doesn't vacate. So I suppose for me, it's difficult to imagine a situation where you conclude an agreement, whether verbal, in writing, whatever the case might be, to not stick to that agreement without talking to the other party. Like, I can't see that, but I suppose that's, the curse of being a lawyer, right? You stick to agreements. If I tell my kids we're going to do, we're going to bake pizza tomorrow evening, come hell or high water, we're going to do that.
Or you find a very creative way around it.
Okay, but that's now parenting acts we're talking about. Or bribery. Bribery works on that as well. But the kids now, everybody, I'm bribing my kids. So I think for me, it's difficult to understand that. It's difficult to understand how people enter into agreements and then not honor their commitments. But at the same time, I appreciate that things happen. I do, however, think in today's day and age, this has probably been the way of the world forever, people unfortunately doesn't take agreements and commitments as seriously as we would like them to see. So on the one hand, I do believe that art clients, for instance, believe that once a document has been signed, it's pretty much as good as an eviction order. So I think what I'm trying to get to is, even though you have a settlement agreement signed, the difference between commercial and residential enforcement of those orders are so extremely worlds apart, because on the one hand, and this differs from court to court. So if we just talk about commercial evictions, we've had so many matters where you will not yet institute proceedings, so you can't comply with the court rules that require an already existing matter that's in front of the court. So you settle that and you can make that an order. It's an out of the blue settlement agreement. Now, in a lot of high courts, we've been successful to make those settlement agreements an order of court, because you include a paragraph that says the parties agreed that this order can be made an order of court. But not just difference from court to court. I must say, in South Gauteng and North Gauteng alike, from judge to judge, with all due respect, it differs. Some judges are happy with those orders and they grant the orders, and some judges say, listen, I can't grant this order. And the reason why the judges doesn't want to grant the orders is because there is unfortunately so much fraud. How must the judge know that these parties are actually in agreement with each other? So how do you find that situation? We can get to residential a little later, because I mean, that's a whole nother kettle of fish. But if we talk about commercial, how do you find, do you have a way of getting around to make it an order?
Look, it's a difficult one, because exactly what you said, bringing a settlement agreement before court, simply with the other party's signature claiming that they signed it, is a bit of a problem. A lot of the judges have pointed out that they'd want some form of representation at court. So we've gotten away with it on many occasions. I suppose if it's during the proceedings and you're trying to make an order settlement, an agreement, order of court, during the proceedings, many times there's some form of attorneys of record, or you can really bring evidence showing that there were emails exchanged. So create a little portfolio that almost builds up to that agreement. If there's attorneys of record, you ask them to please at least brief someone to appear at court. You even tended to pay those costs, get the guy appearing in court, and there you go, you make it an order of court. So during the proceedings, I tend to find it a bit easier if it's outright, without us having gone to court and we enter into some sort of settlement that now we want to bring in a new application to make an order of court. There you do tend to struggle a little bit more, because you're attaching it to the affidavit, trying to convince a court that even before you instituted proceedings, that now you're trying to make it an order, and it makes it a little bit difficult. That's why in those cases, sometimes I still actually make out the case, just so I've got the backup that, you know what, if the settlement if he doesn't want to make the settlement or order of court, at the very least, I've still made out a case and I'm entitled to an order in any event. And I tend to find that works. At least you cover all your bases.
That's a very good solution. I usually don't like to do that, simply because now you're required to have a service by sheriff. But in fairness, I think for a client to spend the extra money on the sheriff to serve the full application is actually totally worth it.
Yeah,
I like that.
Yeah.
I like that solution.
It's prudent, but yeah, I mean, the sheriff's 300, 400 rand sometimes. It's especially with commercial evictions. If your client can't pay 300, 400 rand, he's got bigger problems.
That's very, very true. And then obviously on residential. So for the benefit of our viewers, just a quick explanation. When you do an eviction for a commercial tenant, so which eviction process we follow, funny enough, has little to almost nothing to do with the property type. We don't care about the zoning of the property. Zoning is 159% irrelevant to an eviction. We don't care. I don't even think we ever wonder about it. Like, there's not even a moment where you think about it. The only time where the type of property becomes relevant is if the property is on rural or peri-urban land, and you have people that hasn't had a contract to stay there, but they've had consent. Then we need to make a quick call on, is this an eviction that has to happen in terms of PI, the Prevention of Illegal Evictions Act, or in terms of ESTA, the Extension of Security of Tenure Act. That's the only time where these things become relevant. But when it comes to commercial, retail, industrial type evictions, and when it comes to evictions in terms of PI, so residential evictions, the only distinction sits on the occupant. If the occupier uses the premises for temporary or permanent shelter, even temporary shelter, we have to evict in terms of PI. So I've seen it a lot of times, Bruno, I'm guessing you too, where you have an industrial warehouse, for instance. Your client is adamant this is not a PI eviction. It's not a residential eviction. Meanwhile, back at the ranch, there's, the security guard of this premises has been staying on that premises for years. That is a PI eviction. You can't, just because of the type of property, then do a commercial eviction. The big difference between the two types of evictions is a commercial eviction is quick and easy. We have less steps to follow. It's a simple, reivindicatio is a simple action where you take your thing back. I just did that. I just went from Latin to take your thing back. I can do that. I can translate like that. So it's a simple reivindicatio. It's not a complicated process. And there's no legislation dealing with commercial property. Maybe we should have this conversation at a later Wednesday webinar about the legislation dealing with residential and then the nothingness and cowboy country of commercial. That's a good one. Yeah. So look at Marilee making a note. Yeah, that's a question. So the big difference is if we have to do an eviction where we have to apply the provisions of PI, we have to jump through a whole set of extra hoops. The reason why the hoops are there is not because the legislator was bored and thought, what are we going to do to entertain the world? The reason why
make lawyers' lives a little bit harder.
Just get it. So, and the reason why the legislator brought that in was in compliance with Section 26 of the Constitution, where it deals with a person may not be evicted unless a court had an opportunity to consider that person's personal circumstances. This is why, and I've seen this on the page, the Property Law Alliance page as well, a lot of questions around or comments like landlords doesn't have rights, only tenants have rights. And I think it's important to appreciate that the right of occupation is such a strong, a weak right in comparison to the right of ownership. The right of ownership is such a strong right. It overshadows the poor right of ownership, of occupation. He's like here on this side of Sisto. So we had to bring legislation in just to give the tenant or the illegal occupier, for that matter, a bit of extra rights. I know nobody likes it if we say this, but we can be upset about the law or we can apply it in a way that will get us the results as quickly as possible. So the reason why we can't just make a residential settlement agreement an order of court is we still need to comply with all the provisions of PI. Even if somebody says, listen, I've signed an agreement, I will vacate on that date. The court, in compliance with the Constitution, has to see that this is actually this person's personal circumstances still allows me as the judge or the magistrate to grant this order for eviction. Because let's be fair, and I know we're mostly talking to landlords, watching the show now, or our clients for that matter, mostly talking to landlords. And the message that I think is very important to understand is, I get that it is frustrating. I get that it, especially now, takes for almost ever to get an eviction. I get that. And I get that we're talking about amazing financial losses. But at the same time, we can't leave a country with 57 odd million people to sort of their own devices and trusting that the landlord is a good landlord that won't just kick somebody out for no reason. So as much as you're a good landlord, remember there's unfortunately 20 others next to you in potentially the same building that's, if they're allowed to just do their own evictions, they will leave people homeless and destitute with no recourse against an unscrupulous landlord. That was a long story.
So just to touch on that, I suppose the problem that we tend to experience, and you're right, this is a conversation that we might need to have on a Wednesday and really go into it. But in short, what I tend to find is, yes, you know what, PI came in and it did give a lot of rights to tenants, and landlords are, for lack of better words, pissed about it. And they feel like they don't have any rights. the reality behind it is the legislation as it stands actually does make sense. Whether it was intended for the landlord-tenant relationship is a completely different story. Whether it was intended for the foreclosure purchases is a completely different story, but it does make sense. Don't put somebody on the street without considering circumstances. So now you've got what the intention of the legislator was. You've got, so the second thing now that you need to consider is beyond, sorry, I actually forgot my second point there. So beyond the intention of the legislator, I suppose the next thing is time periods. So our justice system, there's a lot of criticism about our justice system. You know, oh, things take long, there is no justice. So again, we look at the fact that the way that our laws are drafted are actually quite good. The way that we practice law in South Africa is actually good. The way that we've developed common law, the constitution, you name it, compare it to countries across the world, it's actually incredible. We are very advanced in law. Our system, though, our processes, the back end that has to actually execute on this. So the quality of the courts, the availability of judges, the availability of dates, the role, the way that the role fills up, that's a problem. So I get the landlord's frustration, but it doesn't just come down to the law is against us. The law isn't against you, right? There's factors in place. It's the same way that a tenant would argue that the law is against them because they don't have housing. It's not the law that's against them. It's budget constraints. It's maybe the inefficiency of the municipality to find alternative accommodation. Because if all that was done, the evictions would actually be quite quick, because the PI only requires that you give a special notice, right, to a tenant for starters. So that's the extra step that we need to go through. So they need a special notice in order to be able to be informed of all their rights, the fact that you're applying for the eviction, when you intend to do it, what the circumstances behind it are. It's almost the same, tantamount to the criminal law process or the labor process, where you have to, again, advise people of all their rights again and make sure that they're aware of it, right? So it's almost a repetition of rights that they should know, but now you're just telling them again. And then when it goes before court, a bunch of circumstances the court needs to consider. If everything around this worked well and there was alternative accommodation, a whole range of factors that would make life easier, we could probably get an eviction done in a month, 3 weeks, somewhere around there, provided that we give that 14 days notice. So that's just something that now we need to bear in mind as we have this conversation about evictions and settlements. The landlord's rights are there, but it is going to go up and down as our courts become full, then empty. And unfortunately, there's little that we as attorneys can do about that, and little that judges can do about that. That is a systematic issue that needs to be resolved at that level, at a political level, unfortunately.
Yeah, that was a very, very thorough explanation of that. I like, yeah, exactly.
That was
like
the
you
summary.
said.
You should see next week. There's going to be even more thorough explanation.
but I think what you said was very relevant. I mean, in terms of PI, the extra time period we're talking, the time pause that PI forces, is a 14 court day period, not in a 14 calendar day period.
Calendar day, yeah.
So, for crying out loud, I mean, it's not supposed to be that quick. We had a bit of a competition way back when in Randburg match in the firm. I think the quickest eviction I've done in Randburg was 21 days. And then one of my previous partners, Elise Leroux, kicked my butt, and she did one in Randburg in 19 days. And I mean, if we look at those time frames, Randburg match, you can still do a residential eviction. Well, remember in the days before COVID, good times. It just like in Feb, you could still do a relatively quick Randburg eviction, not 19 days. I don't think I've seen 19 days evictions in about 3-4 years. I think it's for various reasons. The roles are more consistent.
Yeah,
and you served at the same time.
Same time, yeah, which you can't do. Yeah.
Just to explain what we were on about, you now you have to serve your notice of motion, so your main application, and then only at a later stage serve your 4-2 notice. The court at that time had it a little bit upside down. So we were able to cheat the system a little in a good way, in a legal positive way. But it was quick. But I mean, now we're talking 6 weeks on an eviction. But currently, in Randburg, we got dates last week. Madeleine, you're going to have to help me on this one if I'm lying now. But our Randburg dates we are getting now for unopposed is sitting in August, right?
Yes.
It's not pretty.
Unfortunately.
Now, maybe we should start that competition again. We see who can do an eviction the quickest. And we start saying, well, I got it done in 3 months. But the days of the 19 days evictions were fun, but unfortunately those days are with us.
Have you had any success stories during the past week with service via sheriff and receiving eviction dates, obtaining eviction dates? I know you did speak about it last week. I just want to know, has anything changed? Have you had any success with regards to that? You know, Bruno?
From my side, I've gotten, at least I've gotten all my applications issued, so I'm happy with that. The dates, I'm still not particularly happy with. I need to ask my colleagues. I've gotten a couple of dates, but I'm still waiting on a few more. I was told today that there were some of the emails bounced. So I think either mailboxes were full or something happened, and they were returned. I did speak to somebody today at one of the associations just regarding whether they're experiencing the same problems. And they assured me that it had nothing to do specifically with evictions, that was all in my head. And that it's...
Well, luckily in mine too, Bruno.
So, but I mean, it was nice. At least, like they took the time, they told me, no, they don't think it is, but there's no way of knowing. On the other hand, we heard from somebody else that it was indeed the case, that they weren't prioritizing evictions. But unless we're there at the court, and it's exactly what Solna said last week, is as attorneys, when I articled, like I went to the court building and I did not leave until I saw the file, until I was able to get a date, and until I found the file or opened a duplicate, whatever the case is. And now that we don't have access to the courts, there's nothing we can do. And it has taken away our power because we endured. And you cannot endure or push or put that pressure if all you can do is pick up a phone that no one has any intention of answering, or sending an email to an address that is not as reactive as you need it to be. So it is a bit frustrating, but that's my position at the moment. And yours?
Yeah, it sounds like my position with Telkom currently. If you can't go somewhere to say, hello, Yella, can I please just get some help here? Yeah, same story. No, Bruno, exactly the same. We've had some also happily issuing our applications. Now, I must say it's a bit of a surprise every now and again with the courts and the deeds offices closing, opening, closing, opening, closing. It feels like a song. It feels like we have to do something about it. It's very exciting. But I mean, I don't know about you, but I would much rather have the courts closed if there was, or the deeds offices closed when they had a person testing positive, than sending my messengers or my attorneys and potentially exposing them, and then not just exposing them, but exposing your entire firm.
The rest of the firm, yeah.
I'm like, I'm actually cool with the courts and the deeds offices opening and closing, because this is the way life is now. It's nobody's fault that they get sick, unless it is, but then you shouldn't be running around licking, random stuff in Woolies, or you should wear your mask and wash your hands. But it's nobody's fault if they get sick, and it is protocol to then close. So with the courts opening and closing, I must say that's a bit of a surprise every time, because like last week, Monday, messenger went out to Pretoria Magistrate Court with a bunch of evictions, and he couldn't issue because the court was closed. It would have been nice if they notify us. Like, it would be cool if we get an email in time, and instead of just a notice outside on the door. But I suppose that's sort of part of new normal. But when the courts are open, we can issue. The sheriff seems to be happy to serve. I haven't had an execution in this time yet. But I know we were trying to get the sheriff to execute, and we are still stuck a little there with the sheriff. Not even if the court says you have to execute, they're still a little reluctant. So you still have to motivate the sheriffs a little bit.
Yeah, absolutely.
Perfect. Thank you for clarifying that. And then we
sorry,
had
Marley,
one...
before your next question, the one thing we forgot to touch on when we were speaking about the settlement agreements, and I just want to mention it before we forget and we leave it halfway. So the whole story that we went into about PI and settlement agreements and all that. So the reality is that if a person signs an agreement, the way to make it an order of court is what Solna said. You have to bring it before court, but you still need to follow the PI process. So why would we go through this effort? Because at least the process starts running. So it's the same thing we told you during COVID. If somebody breaches, send out a cancellation letter. If somebody enters into an agreement and they say that they're going to move out in 2 months, if you wait 2 months, you're waiting 2 months. Going to court with a settlement agreement is not going to make it faster. And that's what people need to understand, because I would, and I mean, obviously it's human nature. I would think if there's an agreement, you should just be able to waltz into court and say, look, there's an agreement, please stamp it so I can go execute it. Unfortunately, the system doesn't work like that. And because of PI, we still need to give the notices. So the way that we make settlement agreements, orders of court, is we still issue the application, we attach the settlement agreement, we explain to the court that that's the position. And there's even been cases, I mean, unfortunately, Greg wasn't here because it was one of his cases that he had, where the court even turned around and nullified a settlement agreement because they felt it wasn't entered into correctly. Obviously, his case was slightly more complex because there were a couple of hundred of people and a couple represented the 100. And then the 100 said no, they weren't actually duly representing them. So, I mean, that doesn't happen on a day-to-day basis, but I've seen people say that they were coerced into entering into settlement agreements. I've seen postponements happen. So for all intents and purposes, the best thing about a settlement is at least the person can't, at least it shoots their credibility down if they come back and try dispute it, number one. And number two, and this is an interesting little trick, is you can always use the settlement agreement to also try and enforce in some of your other rights. So we've had cases where we've enforced payment of rentals and we've made it an order. So we give the tenant a discount. He thinks he's getting a good deal, which he is, but we've got a court order now that entitles us to collect on that rent and to execute on the collection, which you'd, under normal circumstances, need to do by way of a summons. Now, you know, 2 birds, 1 stone, you do it all at once. So there is value to it, but it's very important, it's paramount that you step on it. As soon as you enter it, go to your attorney and say, great, here you go. Please institute the eviction application. Get me an order confirming this guy needs to move out so we can get the ball rolling.
Well, while we're on that, just one little extra tip that I like sneaking into settlement agreements on residential is an alternative address. So to say, I will be moving on that date. I do have a place of residence to move to. Now, the thing is, sometimes the person doesn't have that. And then I say, but listen, okay, say theoretically you can't move to that place. Is there anywhere else you can go? To your mother, to your mother-in-law, maybe? It's going to be fun. You're going to love it. I can say this because I don't have a mother-in-law, so I can make these jokes without dying. But yeah, people always actually have an alternative address. And the reason why it's nice to sneak it into your settlement agreement, not sneak, I don't mean sneak, I mean, everybody should know about it. But the main thing is, if there's a problem with an occupier that will be left homeless and destitute, the court must give them a much longer time to vacate from the date of court order to the date of the sheriff coming to evict them. So if we can already agree between the parties that it's fine, I might not be living here, but I will be living at an alternative address. This is, I do have an alternative accommodation address, then at least it will give you a relatively quicker execution of your order than in your normal circumstances.
Absolutely.
Again, like you said, Bruno, it's not going to make it any quicker, but at least you can commence.
Yeah, absolutely.
Okay, Marilyn, we'll keep quiet now.
No, it's no problem. Thank you for clarifying that. We had a question on the Facebook page. I'm going to read it as it is. He said that he's a sourcing agent and I'm looking for the most safest and legal way to secure a deal via the OTP, making sure I'm thoroughly protected in the case of me not finding an investor to purchase the property. And then he had 3 subsequent questions. First, what do I need to be aware of? What's suspensive conditions? And then as lastly, an exit strategy in the case of me not finding an investor. I don't know. Bruno, do you want to take this one?
Sure, no worries. So traditionally, so obviously the terminology regarding sourcing, assignment, all these terms I tend to find are associated with some form of educational brand. And unfortunately, I'm finding more and more that there's specific US brands that are teaching certain investment strategies that are unfortunately not applicable in South Africa. So we do need to be careful, especially with the use of the word assignment, because things work slightly differently there than they do here. So what do we mean when we say sourcing? So estate agents, traditionally, their job is they get a seller who mandates them. They go find a purchaser. They broker the deal. There you go. So a sourcing agent is slightly different. A sourcing agent goes out and actually looks for specific properties, especially investment properties, and then finds a fellow investor, but somebody with money, to go and take the deal off his hands. So they source the deal on, and by sourcing the deal on, they normally charge a finder's fee for having found their deal and sourced it on. The problem that we have in South Africa is this, and a lot of people argue this, and there is going to be debate around this. So this is just my very high level off the cuff opinion without looking for the gray areas or trying to change wording around. There are ways of doing it, but the reality is this falls squarely within the ambit of estate agents and the Estate Agency Affairs Act. And that act is very clear that if you're doing this, that you need to be a registered estate agent in order to be allowed to do this and in order to be allowed to claim commission. So yes, it's illegal. I've never seen any arrests on it, but it is illegal. But the worst part is that you can't claim commission. So if you go out and sue, you're not going to be able to succeed with your claim because you do not have a fidelity fund certificate. And in terms of the Property Practitioners Act, which we anticipate coming out soon, one of the differences is now, if you get paid a commission, you get paid, no one can actually claim it back from you. So you've succeeded in getting your commission. In terms of the new act, the understanding is that if they pay you a commission and it wasn't actually due to you because you're not registered, they can claim it back from you. So now you're not safe and you're performing a job of an estate agent. So this is one of the risks that I normally encounter when it comes to guys like this. And there's certain tricks around it. I sometimes work with them and they partner up with agencies or with myself, and the brokering actually gets done by a different person, a different team of people that just uses his knowledge, and they actually broker the deal in order to legitimize it. The other way of doing it is a back-to-back transaction. And for most of the people listening to this, well, I don't know, but as an investor lingo, back-to-back basically means that you buy a property from A, you sell it to C, and you don't take transfers. So you basically allow the transfer to almost take place directly from A to C. But in the deeds office, it's actually 2 transfers that take place. And the upside to this is it's totally legal. You don't need to be registered. It's 100%. The downside is that you pay double transfer duty. So it's not always very appealing to people. But it makes a lot of sense, for example, if your profit is huge. So let's say that you're on selling a property for 200,000 Rand, you're never going to be able to justify that as a commission. If your profit's 200 and the property is only worth 400, 200,000 Rand is unreasonable as a comp. But if you're on selling the property, it actually makes sense because then it's just clear-cut profit on a capital flip. So those are generally the two ways, traditional ways of doing it. Yeah, there's other things, but let me actually give Silna a turn. I know that you've also got input on this.
Yeah, I think the important thing is exactly like you said, Bruno. It's it's illegal to do things to fulfill the duties of an estate agent unless you are actually registered as an estate agent with the Estate Agency Affairs Board and you hold a valid FFC. Personally, I know SSLR at its very best sometimes would be a little unpopular with estate agents when it comes to holding of an FFC. On the estate agents we are unpopular with, I'm so happy to be unpopular with them, because the estate agents that actually does hold FFCs prefer that we do this. So what we do to make us unpopular is, if there's a transaction and I do not have a valid fidelity fund certificate for the time of conclusion of that offer to purchase, I refuse to pay out the commission. I will not pay an estate agent commission unless I have a valid fidelity fund certificate. Not because I want to be the hoofmeisie and, you know, police enforcing rules here, but the truth is I prefer that the money flowing in and out of my trust account is dealt with 100% legal. And the reason why we're so paranoid about this is, in the property industry, guys, let's be fair, the industry is so small. We all know each other, and we all know who does what and how it should be working. And unfortunately, as it goes with reputation, especially in an industry as small as the property industry, you can only afford to damage your reputation once, and then it's dunsies. So the truth about this is, on the one hand, if we know you have to be a registered estate agent to fulfill the duties of an estate agent, I can't work with the estate agents and the investors, and then on the one hand help investors to effectively undercut estate agents, and on the other hand estate agents have a very important duty, and that is, they are protected by law to fulfill this duty. So when an estate agent holds an FFC, it does have something that you don't have, but at the same time, it's like being an attorney, Bruno. We've studied for quite some time, and then we had to go through that exciting PLTs and our articles and the whole thing. And I'm very sure there are practitioners out there that are practicing as attorneys, but they aren't. And I wouldn't want anybody to support them, because we do things the right way. And the same goes for estate agents. So that was a very long intro again, but the point I'm making is, just because you can get away with something doesn't mean you should. So getting away with something isn't the gray areas that Bruno is talking about. There are definitely ways of putting a deal together with the right players in a right way that everybody will still get their fair cut. 100%. It can really happen. And we have a bunch of investors, and you too, Bruno, which we've helped putting together deals. They make beautiful commission, and you just see more, and by commission I mean money out of the transaction. I mean profit, not commission. And unfortunately, I've seen investors trying to cut a deal in a way where they are acting as an estate agent. And the problem with that is, like you said, they're not going to go to jail, but you're going to lose your money. You're going to work flipping hard on a deal, and you're not going to receive the commission element on that. So always be careful when you enter into an offer to purchase as a sourcing, for the purposes of sourcing. There are ways of doing it legally and correctly without burning your fingers, but then it's not a true, let's just say it as it is, it's not a true sourcing agreement. If you want to actively source in the sense of fulfilling the duties of an estate agent, you have to be registered as an estate agent. That's basically what we're saying, and there's no two ways around that.
So just to touch on that, so that's why one of the strategies that I normally work with. So I work with a couple of people that actually focus on investment brokering. It's a business that I'm actually a part of, and it's everything's registered, everything's above board, and there's teams of people that actually gather information, they figure out whether these deals actually make sense, and they take over the deal. So they're actually responsible for the brokering. And to a certain degree, then everyone actually gets their fair cut and everything is legitimate. But you have to remember, at the end of the day, estate agents are trained to be able to look at properties, to understand what the issues are. They understand their duties. Fidelity Fund, they've got FFC, so Fidelity Fund certificate. They're able to accept money into trust accounts. They're responsible. So they understand deals. They can't just throw numbers around, because at the end of the day, they're liable for it. So just be very careful, because if you're also going to hand over money to a sourcing agent that's not an estate agent, it's going to be a problem. So on the one side, it's the sourcing agent that might lose money because they go through all this work and they don't get paid their comm. But the reason why the estate agent qualification exists is there's also people that are going to give their money to agents and they're going to be lied to. And that's where the balance needs to be reached. It's a profession because it's a profession. And they're trained to do what they need to do. And some are trained in investment brokering. So you just need to find the right agents to do the things that you need to do. And you as a sourcing agent also need to work with them or structure your deal then differently so that you don't act as an estate agent.
Okay, perfect. Thank you so much. I think that answers the question in full. That is about the time that we have this evening. Is there any last thoughts from your side?
Wash your hands and stay warm is basically what I have.
Just stay warm.
No, wash your hands. Wait, no, I have something profound. Wash your hands with warm water.
Yeah. Thank you. All right.
Twice.
Okay, thank you, Sona and Bruno, and thank you everyone for joining us this evening. And then we'll see you next week.
Awesome. Thanks, Marie.
Thanks,
Okay.
guys.
Thanks. Cheers.
Bye-bye. Bye.